HMC Daily News with your host, Penelope Barrett.
Hello, and welcome to our viewers joining us today. I'm Penelope Barrett for HMC Daily News. Today's top story is a new MEAC opinion. We'll discuss what this means for Florida mediators statewide. An opinion was requested from MEAC asking if a mediator may testify in court regarding activities that happened in a mediation. The mediator asked MEAC to consider the following fact pattern, which has three distinct parts. The mediator provided some background to this unique situation. They state, last year, I mediated a court-ordered circuit civil case for two parties, resulted in an agreement. One of the parties has requested that the court set aside the agreement. The party's attorneys contacted me to request that I testify at their upcoming court hearing and assured me that both parties have waived their privilege to confidential communications. The mediator then asked MEAC multiple questions regarding this situation. They first asked if they could testify at all. They asked, can I voluntarily testify in court if both parties have waived their privilege to confidential communication? I've consulted MEAC opinion 2021-005, but I am not sure that opinion is analogous to my circumstances. MEAC opinion 2021-005 seems to indicate that the court would have to order me to testify. The mediator then moves on to the second part of their question regarding fees. They ask, if I am permitted to testify, may I inform the parties that I will do so for a fee plus expenses? My engagement letter for the mediation did not include fees and expenses for testimony, as I never contemplated doing so. I conducted the mediation via Zoom, and the court hearing is live in another county. I will incur hotel and travel expenses in addition to my preparation time and time providing testimony. I estimate fees and expenses to testify will be over $3,000. Finally, the mediator asked a final question regarding impartiality. They state, does Rule 10.330 require me to only provide testimony that assists all parties as opposed to any one individual? The mediator referenced the following authorities: Florida statutes 44,401 through 406, which discuss confidentiality. Florida rules for certified and court-appointed mediators 10.330, 10.340, 10.360, 10.380, 10.620, and 10.910. Also, prior MEAC opinion 2021-005. MEAC Committee Chair Gladys Stagman wrote the official opinion on this matter. In summary, under Section 44.405(4) Florida statutes, the mediator may voluntarily testify in court so long as all parties waive the mediation confidentiality, or if any of the other statutory exceptions apply. After the mediation has fully concluded, the mediator generally may charge and accept fees for non-mediation services, like testifying or giving an expert opinion, without violating the standards of professional conduct for mediators. Finally, as long as the testimony is true, the fact that the testimony potentially supports one party's version over the other party's version would not violate Rule 10.330A, Florida Rules for Certified and Court-Appointed Mediators regarding impartiality. The MEAC opinion then explains in detail why this conduct might be allowed by discussing the rules presented by the mediator. For more on this, Let's turn to our expert, Dustin Cooper. Dustin, can you tell us a bit more about the rules contained in this opinion?
Yes, Penelope. Why don't we break this down a bit further for the viewers at home?
That's a good idea. We are covering multiple issues here.
First, let's address Rule 10.910, discussed at the top of the opinion. Under this rule, the Advisory Council is authorized to issue written advisory opinions to the mediators subject to the rules. The mediators subject to the rules are Supreme Court certified mediators within the state of Florida. The Advisory Council does not give legal advice or establish best practices for mediators.
It seems that MEAC is laying the foundation to their opinion with the FRCCAM rules this time. Is that correct?
Yes, Penelope. First, the Advisory Council lays a foundation to give an opinion on the matter. Then the Advisory Council discusses the fact scenario presented by the mediator. Next, the Advisory Council tackles the first part of the mediator's question about testifying in court. Here they rely on both Florida statutes and the mediator rules. They state that under Florida Statute 44.405, the parties hold the power to refuse to testify and prevent any other person from testifying in a subsequent proceeding regarding mediation communications, unless both parties have waived the confidentiality or privilege against disclosure. The Advisory Council believes that under the fact pattern presented, both parties have actively waived their rights. Therefore, the mediator is allowed to testify without violating ethical standards.
It seems clear that when both parties actually want the mediator to testify, the mediator is allowed to do so.
Yes, as long as both parties have waived their rights, the mediator is free to testify. And remember how the mediator asked about the prior opinion in 2021?
Yes, they asked about opinion 2021-005.
The Advisory Council clarified that opinion as well. The 2021 opinion states, a certified or court-appointed mediator should not voluntarily testify in court regarding information learned unless confidentiality is waived by the parties or such communications fall within exceptions listed in Florida Statutes 44.405.
So they are saying their prior opinion falls in line with this one.
Yes, I think that is their point. The Advisory Council then moves on to the next part of the question regarding charging fees.
Yes, that's a tricky area.
And it is not one the Advisory Council is allowed to give an opinion on. They state the mediator's rules only governs fees and expenses with respect to services rendered during the mediation process.
I see. MEAC has no ability to give advice in this area since this is talking about fees after the mediation.
Correct. However, the Advisory Council did state that a mediator might generally charge fees for non-mediation services without violating the standards of professional conduct as long as the general ethical standards are respected. They support this statement with Rules 10.340 and 10.620.
I understand. As long as the mediator does not violate the ethics standards and professional conduct rules, they should be in the clear.
Yes, that is my understanding.
Well, I hope they read the rules very carefully when considering the fees they want to charge.
Me too. The Advisory Council then answered the last part of the question regarding the requirement that a mediator remains impartial. Here, the Advisory Council clarified that although the mediator must remain impartial within the mediation process, they are not obligated to remain impartial after mediation. They state, when testifying under oath, the mediator has an obligation to testify truthfully and accurately. As long as the testimony is true, the fact that the testimony potentially supports one party's version over the other party's version would not violate Rule 10.330A regarding impartiality.
From what I can understand, mediators have an obligation to testify truthfully under the rules, even if that benefits one side over the other.
That is my understanding of this opinion as well.
I can understand the problems faced by mediators who get called to testify in court. I don't envy their position.
Me either.
Thank you for your observations, Dustin. As a reminder, MEAC has the power to provide opinions subject to Rule 10.910. MEAC is not authorized to give legal advice or establish best practices for mediators. Each opinion is based on the specific facts of the scenario presented. If you have a question for MEAC, please send your question to Florida Dispute Resolution Center, Supreme Court Building, 500 South Duval Street, Tallahassee, Florida, 32399. You may also email MEAC at the email shown on your screen. MEAC asks that you give details and include any rules you think are related to your question. Written opinions may take up to 120 days and are posted on the DRC's website. MEAC only considers written questions related to the Florida certified and court-appointed mediators who are subject to the rules. You can find MEAC opinions on the Florida Court's website. That was HMC Daily News. I'm Penelope Barrett. Thank you for watching. Good night.